Ladies and gentlemen, dear colleagues, I'm very grateful for the invitation to this conference and apologize that I'm unable to attend it due to other commitments which will take me outside Europe this week. I think we may all agree that in the EU there is recognition of the potential social and economic benefits that can be derived from the commercial use of drones. This is why, alongside industry's efforts in deploying this technology, the EU has put forward plans for its introduction on the EU market and to remove barriers in the EU single market. In November last year, the European Data Protection Supervisor responded to the Commission's April communication on this technology and to research projects under the framework Project 7 framework. We publish our opinion on the EDPS website and we are actively contributing to the Article 29 Working Party's position on this important area. I believe that irrespective of the various regulatory issues at stake, we need better understanding of why, since their infancy, new drone technologies have significant implications for privacy and data protection. These aircraft systems are often combined with data processing tools such as cameras, microphones, sensors, GPS, which allow the collection and further processing of personal data concerning identified or identifiable individuals. A few countries also protect information relating to legal persons. Drones are mobile devices, almost unnoticeable, and it is hard to identify who is using them. So, transparency and accountability are paramount concerns. The trouble is that the current legal framework at EU and national level, specific rules, procedures and best practices are inconsistent, fragmented, obsolete, or too general for industry to understand what needs to be done in practical terms. In Europe, a number of general rules on privacy and data protection are already applicable to the processing carried out via drones, as for example the Council of Europe Convention 108, the Directive 95/46, Regulation 45/2001 and also the European Court of Justice case law. I encourage a more detailed understanding of the technology, informed by an honest and open dialogue between legislators, practitioners, stakeholders, manufacturers, regulatory and data protection authorities. On that basis, we need to build a comprehensive regulatory framework that enshrines personal data protection as a core element. The civil use of drones needs to be better addressed at EU and national level, on the basis of best practices and, where necessary, new harmonized rules which are compatible with Europe's new data protection rules currently being negotiated. So clearly, the civil aviation authorities need to consider the impact on the fundamental rights of individuals when allocating permits. We do not need necessarily to amend European national data protection framework to accommodate drone technologies. However, there may well be benefiting guidelines and recommendations by data protection authorities cooperating on this issue. These authorities may also play an important role in supporting designers, developers and industry to correctly address those challenges and better embed the principles of privacy by design and privacy by default. In our 2014 opinion, I have mentioned it, we highlighted that the EU should play a leading role in raising awareness of manufacturers, users and data subjects on the existing data protection framework, regardless of the size of the RPIAs. At the design phase, manufacturers should implement privacy by design and privacy by default. There is a need to increase transparency towards data subjects and facilitate the identification of the controllers. Data protection impact assessment should be carried out where processing operations present specific risks to the rights and freedoms of the data subjects. And finally, there is also room for raising consumers' awareness on their private use of drones. We are closely following the implementation of the Commission's communication and will continue to monitor and advise on future regulatory developments at EU level in that field. In the joint statement of the European Data Protection Authorities made at the European Data Protection Governance Forum in Paris on 8 December last year, the 29 Working Party affirmed that the data processing through drones by governmental services must be for the purposes laid down in the relevant legislation and should not be used for unlawful cigarette surveillance, bulk data processing, unlawful data pooling and profiling. The Working Party will soon follow up on this statement with further details, and I'm confident that today's panel will build on the very fruitful conference I have attended a few weeks ago in Budapest in identifying big issues and risks and point towards solutions and best practices. So my best wishes to you for a successful event, and I look forward to continuing the discussions.